subsequent appearance bond, which I will do here, but but getting the pieces together, let's give Attorney Davis just a cold call. I think it may coordinate things. We don't have anybody held, and we aren't connected to the correctional facilities on this, on this lodging block, so to speak. But let's just, I'll take the lead if we get through. While we're talking about that, Ms. Renfrew, if you get to that treatment program, make sure you keep checking your address at your mother's. And you say you have Attorney Davis's phone number, correct?
I don't know. No.
Okay, at the front, there'll be some of her cards out front. You can have it. You happen to have an email that you check sometimes?
Yes. Yes.
We're going to make sure she has that. We're going to see if.
Good afternoon, Davis Legal Solutions.
Yes, it's Judge Harris trying to reach Amy Davis if she's available.
She is, Judge Harris. I'm going to put you on hold for just a moment. I think she just ran downstairs.
Yeah, tell us just a check-in on the case from this morning with some developments for her.
Hold on just a moment, please. This is Sarah, by the way. How are you?
Very well. How are you?
I'm very good. Hold on just a moment.
Thank you. Hello, Ms. Ellingwood. This is Ms. Renfrew. There's going to be a treatment court referral we're discussing about we missed her hearing this morning. I think Madam President, but she hasn't started the process. Yes, but Mr. Springer, we're trying to just get Attorney Davis just to let her know what happened. They include $3,000 restaurants being converted to an unsecure with the hope of her moving into the treatment court referral that's going to be fine shortly. Okay. Do you have what program is this? What program are you looking to have the bed at?
Program.
The Divas. Okay. Yeah. Yeah.
Yep. They
Who operates that program? Is it the Divas? That's just a program, though, right? Who? Hi, Attorney Davis. Can you hear me? Okay. I'm just updating. Ms. Renfrew presented herself. She's going to be released, but just want to let you know what's going on so you can see. Okay. Uh, so what's happened? She's appeared here with Mr. Springer. She reported that she knew she had the court today. She thought it was in the afternoon. She did not appear. She is here now, but we have Attorney Snow present. The Attorney Snow, there is an interest in treatment court. We have Ms. Ellingwood able to start doing the screening. The state's requested that that I modified the $3,000 consecutive bail to an unsecured appearance bond. And Ms. Renfrew is going to be starting through the process through the Divas program. She has a bed available at one facility, and we're going to be moving along on that basis. So I just want to let you know we're going to be connecting her with you, but that's the route we're going to be going. I don't know if you have a phone number for her and an email address. I think she may have one or both. I'll perhaps let you just. Okay, you can just forward that stuff on to Attorney Davis. Okay. So right now we're going to be setting it for some kind of a status. The door A, door B discussion will have to occur, assuming there is the clinical screening and the eligibility. But Ms. Ellingwood, right here in the courtroom right now. So I just want to update you. Those will be some of the next proceedings that we'll set. Okay. Okay. With that, we'll complete. Thank you, Attorney Davis. Attorney Snow is. While we complete today's hearing, other things we should take up today?
Are you going to be able to screen her today, or is that going to be a scheduled event?
I can most likely do the ORAS screening today, most likely not the eligibility for clinical, because we need the case manager to be present for that. But I can do a quick screening this afternoon.
I think that would be great. Do you need me to file referrals before you do that?
Yes.
Okay, I'll do it right now in real time. All right, thank you, Your Honor. Nothing. more.
Okay. All right, so Ms. Renfrew, right now, that next hearing in front of me, we'll be setting probably something prior to that January 5th pretrial. The hope is you'll get into the treatment court. You have the double screening. You then have the door A, door B, which to enter the program, that would be in front of Judge Griffin. We'll be setting a back status conference in front of me in case the entry doesn't occur. Okay, but if things go smoothly, that's the way you'll be progressing. You'll have Attorney Davis's card there. Get that. Please contact her and make sure she has your updated contact information, including any and knows where in confirming the Divas program entry and how to best contact you. We'll be setting other hearings. You're going to be signing for an unsecured appearance bond. If you fail to appear in the future, I may impose $3,000 bail. If you have court hearings, make sure you look at the time as well as the date. The time can be very important when we,
Trying
okay?
to get involved with Washington County Mental Health because I got a little head injury.
And yeah, I know,
So I'm trying to get somebody that's kind of in my side support.
no, I do recall, you've had some challenges. But we got to try to get you in a way that we can, get you making your court appearances. Okay. The Attorney Davis is assigned to them. All right. Any questions for me?
Thank you so much.
Well, I'm glad we were able to get it resolved today rather than have you picked up on the Friday or something.
Usually,
in the
honest to
ward.
God, it's really hard to turn yourself in, but I'm on a different level and I'm very
Okay.
grateful today.
Each day is a new day. We'll go forward with. Okay. Thank you.
Thank you, Your Honor.
Thank you. Thank you, Mr. Springer. It's Mr. Hoffman, correct? Hello, Mr. Hoffman. I'm Judge Harris. Give me one moment while I switch over to your matter. I did see an application for a public defender. I was going to put, I see Jason. I'm going to put your last name on this is Jason. This is your public defender application. Yeah. I'll just plug it in, put it in so it's clear. Okay. Thank you. Thank you. I'm going to call your case in just a moment. Ready for me to go forward with the next case? This is State of Vermont versus Jason Hoffman. It's our docket 25 CR 11234. He is present with Attorney Springer. I have Deputy State's Attorney King here today. It's a matter which was just filed today. I reviewed the application or the information filed in support of it, made a finding of probable cause. We're here for the arraignment. I have an application for a public defender, which I'm approving with the $50 copay. This is Mr. Hoffman's only pending matter. Mr. Springer.
Your Honor, I spoke with Mr. Hoffman. I'll acknowledge receipt of the information and affidavit, waive a reading on his behalf, waive the 24-hour rule, restation of rule 5 rights. There a plea of not guilty. I had some discussion with Mr. Hoffman about the state's requested conditions 1, 2, 14, 15, 24 in a pretrial services order. He does not have any objection to those conditions.
Okay, and I do have to, of those the conditions as they were submitted, Attorney King?
Sorry, Your Honor.
So I want to have a little discussion on a couple points. That is one. I do see either the parallel conditions of release, if you will, for Ms. Rogers. I don't. At one point, she might be seeking medical. I don't know if she failed to appear, maybe in medical treatment.
Maybe I'll just put on the record. I did have a conversation with her from the hospital. I think she may have called in.
Yeah.
As she was in the hospital, the nurse who was in the room spoke with me. She's expected to be in the hospital for 48 to 72 hours.
Yep.
I think the tricky thing here is that Ms. Rogers and Mr. Hoffman have inconsistent positions about what they would like the conditions of release to look like. So my proposal would be, I think I can move forward with Mr. Hoffman's arraignment today. And my thought is Ms. Rogers is going to expect to be in the hospital at least till tomorrow, invoke the 24-hour rule and see if maybe
What we could do. So thank you. I thought she might not be able to medically appear today. I see the condition of release. Partly, but partly. Hello? Oh, it's Ms. Hoffman. You have to be able to.
Yeah, so I spoke with Ms. I'm sorry, I thought it was Rogers.
Ms. Rogers, I'm sorry. I apologize.
Yeah, I spoke with her and that was the conversation I had where the nurse informed me about her hospitalization. I had a conversation with Ms. Rogers about the case pending against her and the state's requested conditions. Her position about conditions is inconsistent with Mr. Hoffman's. So the best thing I can think to do today is to proceed with Mr. Hoffman's case since he's here, invoke the 24-hour rule for Ms. Rogers and ask if the court might be able to arrange for conflict counsel to represent her tomorrow at an arraignment.
Possibly have a review of conditions on this one. No.
They have inconsistent positions.
Well, I have the inconsistent positions. The other thing I see is I understand one, they're married. I don't know if they look at these. I don't know if there are any orders being sought or issuing from the family division. And to the extent, my understanding is the two of them have been largely with insecure housing, sometimes living in an RV. And if they're married, the RV is marital property, and what may happen to the RV could be subject to proceedings outside of ownership that or possession outside of what the court may normally order.
I have just one moment.
Yep.
So yeah, I guess what I would suggest is Mr. Hoffman will come back for consideration of whether there needs to be any changes to conditions of release. And our hope is that the counsel can speak with Ms. Rogers. I just feel uncomfortable.
I understand you literally have two people in the same hearing with arguing for or against different condition of release, which may conflict with each other. So if I do, I miss Hoffman. Yeah, yes, Ms. Rogers.
I think that really well, I only do I read, you know, on nothing like computer. And can't be to close. Include my infrastructure.
Well, right now, Ms. Rogers, they don't have you with. What I'm looking at, Ms. Rogers, if you're going to be if you're going to be hospitalized at least tomorrow at 1, I'm going to get other counsel assigned for you. And anything I do today for Mr. Hoffman will be subject to further revision tomorrow. But we have an attorney. The public defenders generally handle arraignments. And part of that, often they may have a conflict, particularly if there are two people that can't represent them both if it's the same incidents. Sometime, very rare, I may have the requested conditions while the matter pending to be in direct opposition to each other. And that puts the attorney kind of in this role where they have the conflicting duties to advocate for each client at the time. And it's kind of an untenable situation. So what we do is get another attorney in to represent the other, but then I'll have the two attorneys and I'll discuss what to do. Part of what is happening here, if you're not going to be released until tomorrow sometime anyway, we can have Mr. Hoffman come back in tomorrow, have an attorney for you, and work it all out at the same time. What I would do when both of you are out, so to speak, is not set at this time. The court would have further proceedings that way. My understanding is you'll be. So I'm not. Well, if I'm doing something, it's just now. It's um, one other thing that if we had it set for tomorrow, and I mean, right now, barring other orders, both parties have had access to the RV. We have Ms. Rogers not present, she has things there. What if we had a condition, we come back to Mr. Hoffman not dispose of property stored in it? Is that agreeable?
Yeah,
I'm saying have her peace of mind.
Oh, nowhere. Yeah, until you people figure out what's going on.
Yeah, so he's fine with that.
Okay. So Ms. Rogers, just to give you some peace of mind, Mr. Hoffman will be required not to just remove your items in the RV. You'll both have an equal opportunity to address the court through counsel tomorrow, and we'll decide what to do. The other, so beyond that, I don't know. Right now, to my knowledge, there's no other family division proceedings. Which
Not that I'm
Okay, so we'll have to work with this from now.
County.
Excuse me?
There's Vermont County against them. He broke
I understand there, but
their right.
I can tell you, well, one, there are other proceedings that may have been dismissed. The court, you know, uh, looking at conditional release, the court sometimes will look at convictions. I also will facially note with that the affidavits here have many conflicting versions of different past events. That I have to sort all that out. Part of it is going forward is trying to fashion an appropriate set of conditions while you both are out while these matters are pending. And so that I'd like to be able to hear from people for each of you as we try to sort that out. So right now he, I understand would have been summoned to be here. You can't be here. I want you to focus on getting that treatment you have. We can resume this tomorrow without negatively impacting your ability to through counsel and all make the arguments you'd like about who might get what access to the RV. Um, Mr. Hoffman was able to discharge his obligation to come to court today to appear for today if he was able to. So I'll set his case tomorrow for a 1 o'clock review. We'll look to get counsel for you. I don't know who that's going to be right now, but we'll look to get someone, and they'll be able to interview you, Ms. Rogers, before you're in front of me, even if you're still at the hospital. And this assumes you're well enough that you participate.
Okay. I got one more question on it. I don't know where nothing is in this area, so I don't know what court is or how to get there.
Have you, well, if you are released, you would come in. Do you know, have you been to downtown Barry before?
Not walk without a walker. My walker's in the RV.
Can I just interrupt?
Yeah.
Ms. Rogers, from my conversation with the nurse in the room when you and I were talking, it sounded like you are definitely going to be in the hospital tomorrow at 1 p.m. So what I'm suggesting is you'll call in again, not that you'll come down to the court in Barry.
Okay. Okay, because I was a little concerned with my disability to walk.
And so it sounds like the medical advice was for you to stay there for 48, 72 hours at least. Are you committed to staying there at least on one so that you can do the I believe she has a cell phone you're on?
Okay, we'll provide that. If we get them in provision tomorrow,
Okay.
okay? I'm going to then complete his hearing, and he's got those orders just to carry us through to tomorrow. Then we'll look at the whole situation again as far as what happens when while these matters are pending for each of you. Meanwhile, next 24 hours, just please focus on your care, and Mr. Springer has your phone number if we need to try to contact you because you're not right on time calling us, and we'll make sure we give you a call on the cell phone number. Okay.
Okay, thank you.
Okay, I think with that, we'll be able to conclude today's hearing. Anything further from the state?
No, thank you.
Is that, if you agree with that way to proceed? I think just to figure this out.
Yeah, this case presents some tricky
It does.
issues, and I'm sure we can work them out, but I think that what the court is proposing makes sense.
Yeah, but, okay.
Thank you.
Thank you. With that, then we'll. Number in the meantime, if you need to see conditions, here's my card number. Okay.
Thank you, Your Honor.
Thank you. Did Ms. Sarah Royce or Sarah Jake?
I'm here,
or knowledge?
Your Honor. I just got out of the hospital from Officer Fry's assault, where I'm not out of the woods yet, and I could still die from how brutal his assault was on me yesterday, where he bent my hips 120 degrees after I told him I could not go more than 90 degrees because my socket could come out. And he said, I don't care, not my problem. Consistent bent me and then thrashed me around. Yeah.
You spoken.
And I've just been ordered on bed rest. I was already on bed rest, so this is just continued bed rest.
Wait a minute, Mr. Springer May.
Ms. Sarah Jake, am I hearing that you cannot physically come to court right now?
No, I have a broken hip. I cannot physically come to court.
Okay. Is there a number that I can call you at? My name's Avi. I'm one of the public defenders. If you'd like representation today, which I would recommend, I can call you. We can talk outside of the courtroom privately and then have you rejoin and do the hearing.
Yeah, I can hear you. Did you get my number? I just gave it to you. Oh, okay.
No,
I'm
I didn't
sorry.
hear you. I'm sorry. It didn't come through. What's your number?
It's going to be 802-207-4941. Now, that is not normally my number, but my other phone is dead, so.
Okay, but I can call you on that number right now?
Yes. Yes.
Okay, so I'm going to ask you to disconnect from however you connected to the court, and I'm going to
It's
call
on
you.
Well, it's on my partner's phone.
Debate it when you're able. Okay.
All right, I'm going to call you in about 30 seconds, okay?
Right.
Thank you.
You handling this under self-connected through you doing the
I am handling.
federal.
Thank you.
Hey, Judge Harris.
Yes.
I just wanted to give you some sort of recollection to there is is it
This is Ms. Sarah Jakes. I'm not going to discuss it right now. Counsel consulting. I'm not going to take any ex parte information
okay?
this time. Just here, prosecutor. She's not counsel. I'm not going to receive other information outside their presence.
Okay.
Familiar with past involvement with some of the prior events in this county and another county. So, but I'm not taking other input orally at this time. Being improper for me to receive it at this point, I believe.
That's fine, Your Honor.
Well, Mr. Springer, I believe Mr. Jake may be present with her. He started to try to interject something. I declined to receive any information he wished. It was a voice from that connection. So I just want to let you know. I just told her I was not going to receive any information ex parte with you not present. So I think that was the phone. Remember, she said she was using another's phone, but. Well, Mr. Springer, I believe Mr. Jake may be present with her. He started to try to interject something. I declined to receive any information he wished. It was a voice from that connection. So I just want to let you know. I just told her I was not going to receive any information ex parte with you not present. So I think that was the.
I'm ready whenever the court.
Yeah. I just want to see if Ms. Sarah, Jake, it's Judge Harris to see if you're back connected through.
Yeah, I'm really out of it right now.
So Your Honor, I spoke with Miss Sarah Jake. She explained to me that she's under the influence of medications because of her injuries, and she does not feel like she understands what's happening. So
Okay.
I don't believe we can move forward with the arraignment. What I would normally do is invoke the 24-hour rule. However, she's telling me these are prescribed medications, and so she doesn't think she'll be in a different position tomorrow. So I don't know if it's possible to reset the arraignment down the road or how the court wants to proceed, but I'm just relaying what she told me.
Sure. Is she is presently hospitalized, is my understanding?
I don't think she's hospitalized. I think she's been discharged rest, but she's on narcotics.
I'm bed rest. Like, yeah, the state would start to turn to the state.
Yes, thank you, Your Honor. Given the seriousness of the allegations and the threats that were made, we would like conditions to be in place, even if they need to be amended when Ms. Jakes does come in. But I would also note CF and made the threat. She was also on bed rest at that time, according to her. So the state does want some conditions in place, particularly that she not come with Main Street except for scheduled appointments.
I'm sorry, someone's talking. I don't know who's saying what there. I don't know if you,
Yeah, so I had reviewed with Ms. Sarah Jake the state's requested conditions. I'm a little, I think, handicapped in responding on the substance, given what I've disclosed, but she did, when I talked about that condition with her, she worried that there may be times that she needs to come to the courthouse to like drop off property or possessions for her child who's in DCF custody.
there could be a schedule. I don't know. My understanding is there may have been, there are other matters that may be pertaining regarding her outside, which involve there's DCF and there's certain things that may involve DCF. I understand involving that has involved certain times to be present in the courthouse. My understanding is I don't know in those proceedings if there were expectations or orders regulating when to be present coming out of a different division. I don't know. I'm sometimes there have been some matters in the family division. Certain individuals, there can be certain orders that may impact, how they interact with DCF. I don't know if that's a situation or not. I don't know. But in any event, I don't know. As far as I don't know to what extent there may be unscheduled times which you might need to be present.
Your Honor, this event happened in the DCF office.
I'm familiar with the affidavits.
Actually, people do have appointments appear there, or if she is on probation and needs to, be in touch with the DCF office, they can schedule an appointment for her. So certainly, if she's coming into the lobby here, that may not be a problem, but I would say she should not be able to go to the DCF without an appointment.
Let me answer this. My understanding is from the affidavits in part, she's been wheelchair bound, not able to drive herself. She has a partner who's resided with 24J. And I'm saying if there are the need to drop things off, seems like she might need someone to transport her, and that person could drop things off as
They denied me in.
for a non-scheduled time without her having to enter the building. You understand what I'm saying, Mr. Springer?
I understand.
And I'm saying I have there. I've court ordered
was,
visits.
That was during a visit time, and those are also court ordered.
Yeah, so the condition they're asking for is you can come when there are appointments. So
Appointments or
visit, you can come for your visit.
scheduled appointments or court ordered visit meetings. I don't want to get into all the any details of anything that's. So it could be just coming for scheduled appointments, which may be with DCF or court ordered meetings. That could include visitation.
I don't even understand it. I'm incompetent. You just dismissed a case of mine 2 months ago from incompetency. Literally.
Wasn't me.
Yes, it was. It's right on the docket. My partner looked it up.
I don't believe I dismissed anything. I don't
you're
think
on the
I've had any of your.
Yeah. Reference docket number 24-CR-10901. That was shortly after the competency eval with Dr. Wecker, and the state, I believe, dismissed that with prejudice as seen in the notice of dismissal in that particular case.
You said he dismissed it.
Your Honor, I don't know that this is appropriate, even if
Yeah.
even if she were found not competent back then. This is a whole new proceeding, whole new date, whole new time, and all we're seeking
I've been so
is to keep.
beat up and screaming at me from the autistic. My partner couldn't hear me yelling, but he heard Officer Price screaming at me the whole time. My partner also tried to leave the DCF building, and they wouldn't let him. They locked him, and they refused to let him out, holding him
That
hostage.
matter of reference was a notice of dismissal by the state following psychiatric evaluation by notice of dismissal. I mean, so the prior to any proceedings, I believe, but in any event, Mr. We need to complete the. What we can do, I think, Mr. Springer, in part, what we might do is get you appointed, looking to complete the arraignment, but would you? It may be in the competency evaluation is appropriate. I mean, the state states its competency that can change. I do know there's been a history of other competency evaluations at different times. I think look at the criminal record history. It reflects a number of dismissals. A number of dismissals across other matters that have been brought, but that doesn't mean necessarily it would be dismissed at the outset. The criminal history, I believe, reflects 78 misdemeanor charges with no convictions, 28 violations of court orders with no convictions. I think that there have been other competency evaluations, but are you suggesting that we just I'd like to see if we're able to go forward with completing the arraignment, but also go ahead, Mr. Springer. I don't know if you may have some thoughts.
Yes. So I guess all I can say is right now, based on my conversation with her, she is not in a position to go forward with an arraignment. I suggested invoking the 24-hour rule and coming back tomorrow, but she pointed out that she'll be on the same medication tomorrow. So I don't know if we'll have better.
Patient for 4 weeks.
So, one possibility is the court can assign me and we can set the arraignment out till next month with the understanding that the court is going to impose the conditions it deems appropriate based on what it knows of.
What would you like to have to come back, Bernie?
I don't understand
Attorney
those
King.
conditions.
As soon as possible, Your Honor. The state has no way of knowing what the medications are, if in fact they're prescribed, or, if this is just a representation, if there's some other documentation as to the medication she's on and how they may impact her, we could consider it. But otherwise, I don't know this, if the state can agree to a month from now, given the allegations, and certainly we do need some temporary conditions.
I have the photo right here.
The state would agree with the ones that you recommended, that she not come here, except for scheduled appointments or
Order meeting or meetings that within an order,
correct.
Um,
The state would agree with that, but to put this out a month seems to be
one, I think I will provisionally appoint you, Mr. Springer. The other thing, if there's the issue of competency may be out there, you can talk to the state and file a motion for a competency evaluation or speak with the Attorney King. I mean, that may well come something. It would be appropriate and applicable for this new matter. I think you also be able to speak with Miss Sarah Royce about trying to get more details about her current medical condition. That might be as far as her ability to go forward, et cetera. Then we'll have to
Your
have to
Honor,
see.
Before this hearing ends, I just saw them on the WebEx with their picture, and they're in a car sitting next to each other.
Okay.
So
Yeah,
I'd really like that.
in other
These are the temporary conditions imposed.
The would you like me to reset this in the lodging block, Attorney King, shortly, or?
I understood the court correctly, Your Honor. You're saying we do need to be provided with some information regarding what medication she's on.
Well, I think
And yes, a lodging block would be fine, but I don't, the state would not agree to a month from now.
no, I'm just looking at something soon, but
Yes.
Someone's presumed innocent. I don't know if
I'm on opiates for another couple weeks and be dead.
so I don't know if I don't know if Attorney Snow is becoming a witness at some point.
I mean, it was just on the video of WebEx, and now, so I mean, I can do whatever you want, but I saw it just now, which is why
I'll leave that to the
apologize.
parties. But if there's, maybe information inconsistent. Partly, people are presumed innocent. We have some self-reporting here, and then
And I just got released from the hospital. That's why I fucking got here from an assault. Yes, that's why I'm in my case, because we couldn't drive and do an arraignment. We just got released from the hospital.
Great, and there'll be paperwork for that, so that's fine, Your Honor. We could do a lodging block tomorrow or Thursday if that suits the court.
let's put it at the Thursday lodging block. We'll set it then.
I'll be in the
And then
I'll be in the hospital.
well, Mr. Springer will be in touch with you and to see where you are and what ability you may have to appear at that time. Miss Sarah Jake. So, and ma'am is.
Last time took it as a suggestion.
So, and I don't know if there are other. So I'll.
But I will.
You're getting so upset. I can't even understand some of what you're saying, ma'am.
So since these conditions are being imposed,
I'm asking you to impose this thing with the condition of visits as well, not appointments and shit, because they'll take it as suggestions.
It's a little hard for me to still
But
understand, Miss Sarah Jake.
Your Honor,
no one listens to
Second.
me.
I'm gonna be able to do anything.
If I don't get my visits, I'll be dead.
Suggest that we come to a decision about what conditions of release we can impose now and then schedule her for Thursday. This is just going to continue to de-escalate
I-
at this point.
I'll set the conditions again that you not come to the 254th North Main Street except for scheduled appointments or court-ordered sessions. You know, that would include. We'll just set that now. We'll set this Thursday at 9 o'clock. Are you present on Thursday, Mr. Springer?
Again, nothing for my child. Thanks for making me
Okay.
lose his birthday. I'll be dead on his birthday.
That's what we'll do at this time. We can consider also any, if there are any motions for, competency, those can also be filed at appropriate time. If those are filed, obviously they aren't acted on immediately. I don't know if we would get into if she is here, possibility of a screener. Yeah, we'll just see. All we can do. I think that's what we're going to do at this time. Anything further, Attorney King?
It's not cruel to me.
May Snow is
Oh, okay, very well.
be handling
Okay,
further court appearances, et cetera.
I think further, Attorney Springer.
I'll be suing
Oh,
you,
thank you.
Harris.
So we'd look to see you at the Thursday at 9.
Since you were supposed to take that originally and you didn't. You left my case.
I'm not going to be discuss. That's going to be the end of your hearing, Ms. Sarah Jake. Thank you. With that, we'll complete your hearing.
So I'm gonna take if they schedule you for a visit, I'm following you. Understood?
gonna go.
I didn't quite hear it.
Yeah, then.
Didn't
And I'll
understand you,
make sure
but we are going
file
to
a
complete your
million
hearing.
motions in that courthouse, so that for I have a million reasons
We're
to
going to
be in
complete
it.
your hearing, ma'am. With that, we're going to disconnect. Now I'm deeming it to be disruptive and preventing me from being able to complete the hearing. So with that, we're going to conclude the hearing. Thank you.
Thank you.
I think that completes the one. Thank you, Mr. Springer. Mr. Springer, if we get counsel for Mr. Hoffman, should we ask them to contact you? This is counsel. If we get counsel from Ms. Rogers, should we?
Phone number. Give it.
We're hoping to appoint someone, and if they do appoint them, if they wish to speak to you, just to start to discuss things, is that agreeable to you? Okay.
Phone number is 802-336-9220. No.
Hi, Your Honor.
Hello, Mr. Lamanda, thank you for being present. Completed our 1 o'clock block. We're
I had done it, but no, I certainly been a while. Yes. Let me just make sure I filed that. Big. And I have the RJOs. Both of them? Yeah, that was for the bank. So I'm fine with you doing like we have the records. for it. Yeah. Can I see that docket number real quick for to make sure I filed the amended? Thanks.
Sign for everybody but you.
Yeah, I see one.
All right, please.
We get some Martinez matter. I think I'll have a question on what are we going to go through first?
What are the choices, Your Honor?
Oh, Mr. Forcier will likely be quicker.
Why don't we do Mr. Force here? But
Donnelly's just logged in.
this Attorney Donnelly, it's Judge Harris. Can you hear me okay? Attorney Donnelly, it's Judge Harris here in the courtroom. Are you able to hear me okay? I don't know if she's coming down.
I'm teamsing the office, Your Honor.
Okay, we'll see. Well, Mr. Forte, I'm Judge Harris, as you'll recall from prior hearings. Um, This is Judge Harris in the court map. Someone's calling through with the number ending in 1-5. I'm not sure what it is. If you like to identify yourself.
My name, yeah, my name is my name is Jonathan Garno.
He's early, maybe.
I think Jonathan Garno. Yeah, we're scheduled 2:30 for you. We have a couple matters we're taking up, but if you wish to just and Mr. Sawyer's your counsel. I mean, he's not doing the 2:30. If you just wish to remain connected but mute your phone, we
Okay.
to your case, sir. Thank you.
Okay, thank you. Bye.
You have Mr. Oh, you have one of his too?
I do.
Yes, I do see that now. On but the
It's just like
Attorney Donnelly, it's Judge Harris. I see her disconnected. I wonder if she's coming down.
that's the whole office to write.
Snow says just a few moments ago she was connected through. So I have to get my JA in here.
You guys have a plan? Okay.
I'll have a couple questions that we get to. We're going to do we're going to do Mr. Force here, man. State's Attorney Donnelly, I think, may be coming down. She was connected through, and then she's off screen.
You know all that.
The number you see connected will be Mr. Garno, the one ending in 1-5 for our 2:30 when time.
She is. Sorry, and we'll either be online or come down in a second.
Okay.
So jump on WebEx, Your Honor.
All right. Thank you. Hello, it's Judge Harris again here with the Force here matter, looking for Attorney Donnelly.
Yes, sorry, Your Honor. I misread my calendar and was planning on coming down later. Apologies.
That's right. The 1 o'clock block ran a little late. We have Mr. Forcier here with the Mr. Lamont. I'm going to call the case. It's State of Vermont versus Jacob Forcier. It's our docket 24 CR 4077. Attorney Donnelly's appearing remotely for today's hearing. I have, as I indicated, Mr. Lamont is here at the defendant. This matter, the last time, excuse me, we were together, there had been, back before Mr. Lamont was appointed, there were, DCF records have been requested, returned, etc. There was an outdated felony scheduling order. There was one submitted on April 1, which was the last court event, if you will, although it was a revised felony scheduling order, which called for November 2025 trial readiness, in essence. So I guess we're here trying to see where this matter stands as far as preparation for trial or other issues. Nothing else has come to the court's attention via motion in the meantime. Mr. Lamont, if you'd like to start.
Yes, thank you, Your Honor. The issue of the DCF records, I wasn't you though. Yes, I think all discovery issues are done, and so we can be prepared for trial.
All right, and that has an offer been extended, even if it hasn't been accepted at this time?
I think there has been discussion of offer.
Okay. Let me turn to Attorney Donnelly. Turn to Attorney Donnelly in a moment.
Hi. Yeah. Yes. I don't know. I don't think that there was an offer made in this case. The last time Attorney Lamonda and I discussed it, he let me know that he thought that his client did indeed want a trial. I certainly can extend an offer. I don't think, we said on our felony scheduling order that this would be a November trial. I don't think there's going to be room for it on the November schedule. But if the court wanted to put it on January, I think we could do that.
All right, the uh, Mr. Lamonda, the January pretrial will be January 5th with the draw on the 7th.
Objection.
Okay, we could do, this would be a pick and go, so to speak. So we would, have that. I think after the 7th, we'd have the after part of the afternoon of the 8th and also the 9th. But what we can do is look to start to schedule this in so it's there, just so if we have some of these, life offense cases being set on the trial, I'd like to get them on there so we start to think about overscheduling them with other matters. What is the expected duration of the trial? If we really do that pick and go on on the day after the draw, because there are arraignments and lodgings, we get going at 2:00. You could do like openings. Then traditionally the next day, the Friday, is open as are parts of the next week. But I'm just trying to get an idea how long of a trial we expect.
I would think that it would probably be that half day Thursday, all day Friday, and the following Monday as well would be what the time I would budget for this trial.
Yes,
If I be able to get in during that day and a half of starting at 2 p.m. on Thursday and then going all day Friday, but I would want to make sure that the court reserved that Monday because they might need that time for deliberations.
sure. We'd have the January 8th, January 9th, and then right now, give me a moment. Oops. The 13th would be the next trial day. Someday we have the trial day on the 13th, not the 12th. That'd be Tuesday. But it's what we have scheduled right now. Okay. Are we expecting prior to the pretrial trial any kind of motion practice of preparation for?
I'm not ruling that out yet. I will be
Okay.
discussing more of those issues with Mr. Forcier, but we'll get those filed.
Okay, we can look to schedule anything on that. Okay. All right. So if we to schedule it at present for those dates with that pretrial conference and all. So right now, then, if there are other things that need to be taken up prior to that, can be requests. We can look to get them appropriately scheduled. Is there other things, Ms. Donnelly, we should take up on Mr. Forcier's matter?
I think so. Thank you.
All right, you all set on this one, Mr. Amon? I am, Your Honor. Thank you, Mr. Forcier. Your attorney will be in contact with you about next hearings, okay? Beyond anyone's beyond these.
All right. Thank you.
Thank you.
I did not file it. I emailed the amended information.
So,
Yes.
I think, while wait for Mr. I had two small points on this. I'm going to get maybe these Martinez, thank you. I'm going to start to get your couple of documents in front of me before we go forward. on your case here in a moment. So there's some amended information being filed in the 10615 docket.
Yes, I believe the intention was to amend the felony
Yep.
offenses to misdemeanor.
Just getting a couple things in front of me real quick before we go.
All right.
Find the amended information.
Sunday morning, I work here. Sunday morning, they do Sunday morning, they'll be fine. But she I work Sundays too, so from 8 to 4 on Sundays, sometimes 12.
Sunday to Thursday.
Actually, it's work Sunday too, so Sunday, yeah, through Friday. Work Friday stay, but I'll be able to get a certain time.
You work Thursday night into Friday morning.
Yes.
And let's say the Sunday morning.
Sunday morning, because that's fine.
You have that copy of that. We'll get in the case. Let me just get over to it. I'm sorry. Do see it. Thank you. So we're going to do one question for council on the plea agreement, the small point. The docket 234620 on the first page, it says WNCR. Isn't that still carrying the LECR from Lamoille? That's the Lamoille case. I don't think it was transferred here for purposes of this.
Yes, I think that would be correct.
And the other one, the 23 CR 7384 is the new convention, if you will, and that's one that's here. That was the burglary here. But any objection of just the void confusion if I change that WNCR to LECR?
No objection.
See? Okay, thank you. The other question I would have before we get going, I understand there was a combined probation, but that both matters. The violation of probation that there's going to be the admit and continue would be for November 7th, 2024. It did alleged violations, I think, of condition A, B, and C. Are we doing are we looking for violations on all three conditions or just say a condition A from entry of one of the new convictions?
Fine with A if you are.
That's fine. I did discuss the three grounds, but any of them.
Yeah.
Okay, condition A would be so we can use the any of these probably the new false pretenses. Okay, before we get going,
There was one other, essentially an amendment in addition to the plea agreement, I believe, with the state's agreement. Just talking to Mr. Martinez today, he has agreed to serve the 30 days, but he is employed. So we would ask that the minimus be that he serve the 30 days on weekends from Friday afternoon to Sunday morning.
okay, is that agreeable to this state? So I'm going to use I have the one copy here, which I'll in front of me, which I'll probably use and put into Odyssey. Give me one moment. Okay.
And we are finishing up 2 restitution orders right now.
And I'll talk about the restitution order. So we should have that. So to serve time to be served on weekends. What's the first report date?
We want to give some more time.
Yeah, what is next Friday? Is that the next Friday's Halloween?
That is that can be the report date? You tell me. I don't.
Yes, 10/31.
Okay. So I put on the page 1 to put report
report date 10/31. What time, like a 5 p.m. or something? You by 5, you can get there earlier.
When I get out of work, I'm at 5, it takes me about an hour to get here.
You can work at 5,
Right, so
7 p.m.
7 p.m. and then to be served on weekends. Is that agreeable to the state?
Time do you go to work on Sunday?
we're about 8. So yeah, so 6 would be good. So if I got in 6, I got an hour drive.
8 p.m.
No, 8 a.m. Sundays. Get it? 8 a.m. So 6 a.m. will be fine. I can make it in time to work. So then an hour drive.
6 days a week.
Yeah,
Saturday's your day off.
yeah. But some Sundays I get half a day. Honestly, some Sundays I get half a day. So I still want to work to get the money I need to survive. To be honest with you. Gotta judge.
The
But working's good. I never want to.
well, if I had a August October 31 7 p.m. report date to be served on weekends, I'm not sure how they would define that. If we're looking at something that's literally one day per week for 29 to 30 days, there's no any credit for time served on these.
Think you've ever held.
Yeah.
I mean, yeah.
That's going to take longer than the period of. Well, it's a to serve, I guess. There's no probation on the so they can continue on the probation, what the term is on the probation, but the to serve portion might continue beyond the probation length.
Yeah, if that's really counted as a day and a half, it may take 20 weeks, but that's. Yeah, again, I think Mr. Martinez accepts that as.
To be served on weekends, we say are they going to be served on weekends from 7 p.m. Friday and 6 a.m. Sunday, something like that. Is that agreeable to the state? Okay, I'm going to put that on here.
Yes, Your Honor.
Okay, I'll put report date 10/31/25, 7 p.m. Who's served to be served on weekends. From 7 p.m. Friday to Sunday, 6 a.m. Okay, I've got that. That takes care of the report date. I think we're otherwise ready to go here in a moment.
Yes, and I do have the execution orders.
Yep, I can take those. You. Okay, so what we're going to do is, here's what we're going to do, Mr. Martinez, we're going to, steps of our hearing today, you reached a global resolution, and we're going to talk about the agreement you've reached. We're going to talk about the rights you give up by completing the agreement. We're going to go through these charges. There are 2 new misdemeanor cases. We'll talk about the elements of those offenses, make sure you understand them. I'll hear the facts that the state expects to show in support of them. Look for your agreement. I'll take your plea from those. We'll talk about the violation and probation process. There'll be one of those convictions, probably the false pretenses, would be served as a violation of a condition of your probation, not to not to have a new criminal conviction. Then those would be noted on the violation probation dockets with admit or continue. So just to be clear, I guess I realized just now I have not yet, I think, called your cases here. So these are, let me just get these are the matters of state of Vermont versus Louise Martinez. We have 24 CR 5871, 106, 24 CR 10615. Those are the new matters not yet been adjudicated. And also there's also 24 CR 13008. The violation of probation dockets, one of them is a one from Memorial just transferred over here for purposes of the hearing. That's 234-6-20 LECR, and 23 CR 7384 is the other one. That's a Washington base. There was a cross-county resolution with a same probation. So if we look at these, those are the cases. There are some cases are going to be dismissed. And so in the 5871 docket, that is a retail theft matter that's going to be dismissed. There is the docket 24 CR 10615. And when I talk about things being dismissed, that means if you complete your agreement, the state cannot refile or pursue you on these cases that are being dismissed here. Attorney Snow, can you confirm for me that dismissals will be with prejudice? I'll be checking that box on the plea agreement version that I will sign. So on that 10615, there is a vulnerable adult exploitation charge, which will be dismissed with prejudice. What's happened is the original count 1 has been it's been refiled or amended to a misdemeanor version of false pretenses or false tokens. For that misdemeanor charge is one you'd be entering a conviction. Maximum penalty for that can be up to a year imprisonment, a fine of $1,000, or both. You have a different result under your agreement. There'd be no fine to be $147 surcharge, and there would be a sentence imposed of 29 to 30 days. I don't have the ability to forgive or reduce the surcharge. So far, is that consistent with understanding, sir? So far? Okay, thank you. So going to continue through then. The other matter is the retail theft. That's in docket 3008. On that retail theft, the maximum penalty can be imprisonment up to 30 days, a fine of $500 or both. Your plea agreement for that second misdemeanor would have no fine. Again, I have to impose that $147 surcharge without the ability to forgive or reduce it. It'd be 0 to 1 days, but it would run concurrent, which means it would overlap. And, when you serve that first day on the first case, that would satisfy the 2-serve sentence on the retail theft. So this contemplates with the new charges, no new probation for those, but there will be you'll be continuing probation under the other matters in which you're under probation at present. What we have for the violation of probation complaint from November 7th, 2024, 2 of the claim violations would be withdrawn with prejudice. There'd be the violation of a condition A, not to have a new conviction entered, where you'd be admitting to that violation. And what would happen there is that you'd be continuing on those probation orders with no changes in the term or the conditions that you are currently under. The other, so far, is that consistent with your agreement, sir?
Yeah.
Now, the other thing we're going to have is there's the idea of restitution. And as you heard, you're pleading guilty to one retail theft in the false pretenses docket. So you're pleading guilty to the one retail theft. There's the false pretenses, and then there's a dismissed retail theft. Restitution is the orders that can be ordered if you are convicted of, generally, if you're convicted of a crime and there's a victim that has an uninsured loss. What also can happen if there's a charge where someone might seek restitution, that if it is dismissed, restitution can be ordered if you agree to it as part of a resolution. Common sample where restitution is sought would be a retail theft matter. And what it allows someone to do, the state can get an order for the merchant to be paid back for the merchandise. Defendant can get the matter cleared, but doesn't have to have a criminal conviction entered to do so. So it gives them flexibility. I'm going to talk a little bit about restitution. Normally for restitution, you have a right to a contested hearing. Even after a jury trial, if someone was convicted of something where there was uninsured loss, after that's done, you'd have a hearing in front of a judge for restitution. The judge, he takes evidence to decide if there is this uninsured loss or repair of property or money that's been taken and hasn't been recovered. The state brings in witnesses who are testify under oath. Your attorney can cross-examine those witnesses, call witnesses, including you. it's like a little mini trial on that very tight issue. And the judge just has to find by a preponderance of evidence that there is some amount that is due. Say someone damaged someone's car intentionally. If they had car insurance that covered all but $200, restitution's only $200. That's the uninsured loss. If the full repair bill was $1,200, no insurance, that restitution order could be $1,200. Restitution is such that it doesn't carry interest, these judgment orders, but they do not go stale after 6 years, like a small claims court judgment, say. There is also a consideration given of the ability of the person responsible for the restitution to make payments. And if they aren't able to make payments at this time, any order to make payments gets deferred to another time. So what your plea agreement has? I have whether two or three of these. I see a double-sided one. So what I have in front of me in the matter involving the false pretenses, there'd be restitution the amount of $1,243.20 to payable to Sarah Dwyer. The payments would be made at $100 a month starting December 1 to the restitution judgment unit, which would pay that to her. There is a retail theft on the dismissed case, 5871, $5.04 payable to the Walmart. Yes, to Walmart. Wait, 1,000. Yeah, $5.94. And so that it looks like it would be paid within 2 weeks. Is there restitution being sought by Kinney Drugs in the 5871 matter?
Doesn't look like it, Your Honor. Said that she filed everything.
Okay. Very well. With the RGO, the plea agreement calls for it, I'm saying, and I believe in the 5871, which is listed there, preparing for today, I thought there was a draft restitution judgment order for $5.04. I guess I want to be clear if that's being pursued at this time or not, because it is called for under the terms of the plea agreement. If you turn to that matter, you'll see a proposed restitution judgment oral filed February 25th. Now you see that if you look in the documents.
I'm writing the advocate to see if she can
Clarify if that's still being sought. I can start. We could start to. We can talk further in that discussion. Did I describe your agreement accurately, Mr. Martinez, today? Any questions about it? Okay, and the probation conditions I'm not going to review. They're just the same that you're on. Okay, very well. I'm going to start with the criminal matters. Talk about the rights being given up now. Sort of transition into the VOP matter. Slightly different considerations there. But you have a right to a jury trial. And at a jury trial, you'd be present when 12 members of the community are selected to serve as a jury. What happens is the state has the burden to prove a crime for you to be convicted of it. Some of these charges have more than one charge being heard in the same case. The jury looks at the evidence separately. So if there are two charges, they might convict you of neither, one or the other, or both, depending on how the jury finds the evidence. The manner the state tries to carry out the burden, witnesses are placed under oath here. Mr. Lamonda can question those witnesses in front of the jury. Mr. Lamonda can challenge evidence the state wants the jury to consider. It could be body cams of officers, different testimony, and the court makes a determination what the jury is allowed to consider. The state does not bring in people who have information helpful to your defense. Mr. Lamonda can get court orders requiring those people to attend your trial and give testimony, even if they don't want to cooperate with the system or the process. In order to convict you of any particular charge, for that charge at the end of the trial, all 12 jurors all have to agree for that charge that the elements, the parts of it have been proven by the state. There's a certain standard or burden the state carries when we look at measure how convinced, how certain does the jury have to be. There's a concept called beyond a reasonable doubt. Here's how partly how we describe it to juries. We tell them that that concept would mean if they find from the evidence you probably committed the crime, more likely than not, a little better than 50-50, they should find you not guilty, insufficient level of certainty. They're told, though, when they look for reasonable doubt as to whether or not you are innocent, they should not guess, don't speculate, don't make something up. That's not a reasonable doubt. They're also given the guidance they do not have to be absolutely or 100% certain. So beyond a reasonable doubt, it's an in-between standard from saying that someone probably committed the crime, greater than that, but not requiring absolute certainty. Do you feel you understand those? Those. Thank you. Thank you, Mr. Martinez. At your trial, you would not be required to testify. If you chose not to testify, the jury be told to draw no conclusions from that decision. They'd be told you never have to say a word during your trial. However, after the state um, puts on its evidence, you'd have a private conversation with Mr. Lamonda and be able to testify if you wish to do so. If so, Attorney Snow could also question you in front of that jury. As the trial comes to a conclusion, and Mr. Lamonda might put on evidence, maybe not. The jury hears the arguments of the attorneys. The judge instructs them on the law. They deliberate. They return a verdict. If you are found guilty of more than one charges, you have another set of rights associated with an appeal. There, you have a right to an attorney. You have a right to have the trial results reviewed by 3 to 5 members of our Vermont Supreme Court. That review panel, if they find significant errors in how your trial is conducted, can reverse a conviction or order a new conviction, a new trial for you. Excuse me. So if you complete your agreement, you give up the right to a trial and the right to have the results reviewed on appeal. Do you understand those rights, sir? Thank you. Do you understand if I accept the agreement and impose the sentence called for in it, if you later have a change of mind and wish to withdraw from that agreement after today, there can be limits on that right to do so later. Do you understand that? Thank you. There was a document called a Notice of Potential Collateral Consequences of a Conviction. And this is, I'm going to ask you in a few moments if you feel comfortable going forward with your hearing today, even after opportunity to consider 2 new misdemeanor convictions. These 2 new misdemeanor convictions. Convictions can have impacts separate and apart than the sentence I impose. And those impacts can vary from person to person depending what else is going on in their life. Some convictions for some people can affect eligibility for certain jobs, certain government benefits, certain licenses. Generally, having convictions can mean can mean if you got in trouble with the law in the future and the judge was sentencing you, he or she might be harsher in sentencing you at a future time. For people who are not U.S. citizens, I don't need to know anyone's status. I need to let you know if you're not a U.S. citizen, entry of some convictions can lead to deportation or removal proceedings from the United States. All that being said, you feel comfortable going forward with your agreement today, sir?
Yes.
Thank you. Mr. Lamond has been your attorney. Are you satisfied with the legal advice he's given you?
I am.
Thank you. He may have forewarned you, Mr. Martinez. I have to ask a couple questions about the clarity of how you're thinking today. There can be some things going on that may make it inappropriate for me to accept the plea, things I can't tell looking at someone. I'm going to ask you in advance, please don't be offended by these questions, okay? I need to rule some things out. I've had people in front of me, they may be very nervous and anxious. They can have panic disorder, different conditions triggered in their mind. And that's not an issue per se, but the issue can be if they get wrought up inside. Anything like that going on for you today, sir? Any drugs or medication, including side effects, impacting your ability to think clearly? Thank you. And I thank you for your patience there. I did not mean to suggest any of that was going on for you. We're going to look at the we're going to talk about the element. We're going to move on to the portion of the case. So I have those in mind. I'm going to move on to the criminal charges in a moment. But first, I just need to describe for you the rights you're giving up with the violation of probation. This is part of your agreement. When someone is sentenced on these matters, you were sentenced in the Lamoille case and in the Washington case. when you're originally sentenced, it would have been, I think, a combined 1 day to 3 years, I believe, on the Burglary case, and 0 to 6 months on the Loyal case for false information and violation of condition of release. What happens is when you're subject to that probation conditions while on probation, if your probation officer believes some of the conditions have been violated, he or she files what's called a violation of probation complaint with affidavit, alleging that you violated some of those conditions while they're in place. You have a right to a contested hearing. You would have counsel. At that hearing, it's in front of a judge, not a jury. The state, it's a formal hearing with the state, with witnesses called, cross-examined, subpoena powers, get people to attend. You can testify or not. The state carries the burden to show, one, that you had a condition of probation in place that you were aware of. Two, while it was in place, that it was violated in some manner within your control. Pretty simple elements. They can vary quite a bit in the application of how they arise. Um, the Unlike a jury trial, it's the judge who decides it. Unlike a jury trial, it's a lower standard of proof, more likely than not. Preponderance of evidence is sufficient for those purposes. What's important to know that if they have such a hearing and the state fails to show the violation, the notice, the violation probation gets dismissed, and you continue on probation as if it wasn't filed. If it were to be found that there was a violation, there's a wide range of results that can occur in a fully contested hearing. The judge could hear arguments from both counsel, and the judge can do something as mild as noting the violation but not changing probation, or the judge can do things like extending the term of probation, modifying conditions, asking or ordering someone to serve part of the suspended sentence, or if other showings are made, the judge can revoke the probation and it becomes a two-serve sentence. There is some limited rights to appeal to the Vermont Supreme Court from the court's rulings in that. So right now you're giving up the right to that contested hearing under your agreement. Do you understand that, sir? Okay, thank you. So we're gonna go on to the criminal charges. I'm going to start with the misdemeanor amended charge of false pretenses. This is in the docket 10615. The state would need to show that you were the person involved. That happened in Washington County on around August 24th of last year. Would this be taking a bunch of variations of this? Would this be obtaining money? Or I'm just
I was saying he used the debit card to obtain property with the intent to defraud.
Use a debit card to obtain money, you mean? Obtain property, yeah.
Really, yeah.
Would it be
Okay.
So basically what they do, they talk about by false pretenses, obtaining property of another person with intent to defraud. So what happens with a debit card or credit card? The state would have to show that you used it falsely indicating that you had permission to use it. In other words, you're using it as if it's your right to use it. They have to show you did not have permission, and then that you're using that when you don't have the permission to obtain with the debit card, cash out of an ATM, or it can be a transaction with a merchant. You're obtaining property of value when you don't have the right to use the card that you're falsely representing. By using it, you have the ability to do it. And then they have to be with the intent to defraud. The intent to defraud would be the jury inferring that when someone does that without permission to use a card to obtain property, typically leaves the store with it, they did so with the intent to deprive the merchant of that property, even though the financial transaction could be reversed because of the card not being authorized. And they have to show that there is a value of the property so obtained. Here would be $900 or less. You feel you understand the elements of the offense, sir? Thank you. What would attorney, if you could please stand up for this portion, if you would please, sir, Mr. Martinez.
For clarity, Your Honor, do you want me to go through the transactions on the 24th through the 30th?
Under which?
Like there's certain debits on the 24th the 25th.
Well, just if you could just the general facts about the obtaining the use of the card without permission, then some use of it on or about August 24th. I didn't see. Um,
It's just how we get to the total for the RJO.
Oh, the RJO, I think, has been stipulated to. I understand the RJO would be an amount in excess of $900, whereas the misdemeanor is property of $900 or less. For purposes of the factual basis for the misdemeanor is sufficient to have him admit the value under 900, and then that doesn't, to the extent the greater charge has been dismissed, that doesn't vitiate the enforceability of the restitution judgment order.
Okay, thank you, Your Honor. On August 24th, 2025, the defendant entered Harry and Lloyd's located at 27 Granite Street in Barry, Washington County, Vermont. While in the store, the defendant provided a debit card owned by James T. Hart. The defendant did not have permission to possess or use that Mr. Hart's debit card. The defendant used the debit card to purchase a Nintendo Switch, PlayStation, and PlayStation 5 for a total purchase of $695.39.
Okay, thank you. On August 24th of 2024, did you go into the Harry Lloyd's store in Barry, Vermont, sir? Did you have a credit card that or debit card that was issued to a James Hart, perhaps, sir? And did you have? Is it accurate that you did not have permission to use the debit card that day? And did you use the debit card to purchase a Switch 5 Nintendo unit with about just under $700 in value? And did you do so with the intent to deprive the merchant from being able to be paid for that? Thank you. I'm going to ask you that the amended information, Mr. Martinez, to false pretenses or false tokens occurring on August 24th, 2024 in Barry, Vermont, regarding Mr. Harp's debit card and the acquisition of the Nintendo unit. What is your plea to that, sir? Thank you. I'm going to wait to accept all your pleas until we get to the end of the case. So we're going to go then for the next charge is the retail theft in docket 1308. You can be seated for the moment. I'll have you stand when we get to the part. The elements of this retail theft have some similarity to the last one. The state would need to show you were the person involved. That happened in Washington County here, Berlin, here in October 30th, 2024. They'd say with the intent of depriving a merchant of possession of merchandise, you took and carried away merchandise without paying the retail value. So there's some aspects of that. When we talk about possession of merchandise for a retail theft, merchants lay merchandise out in the store. There's an invitation for people to come, look at it, choose something, and purchase it. The store owner continues to have the right to keep that merchandise in its possession, in its store, unless someone pays for it. So part of what happens with this charge, someone would come and take some of that merchandise, leave the store without paying for it. And it has to be with the intent, again, that the jury can infer of depriving the merchant of that possession of the merchandise without it being paid for. When we talk about that intent, is an essential element. There can be examples when someone walks out of a store with merchandise without paying for it, but they lack the intent. An example would be if you were in the store with a friend and had a backpack or something and they slipped something into your coat pocket and you had no idea it was there. You would have walked out of the store without paying for those items, but lacked the intent. That's different if someone sees you taking it, putting under your coat, or you just pick it up yourself and walk out. Do you feel you understand the elements of this offense, sir? Thank you. Have you please stand and hear from the state what they expect.
Thank you, Your Honor. On Wednesday, October 30th, 2024, the defendant entered Walmart located at 282 Berlin Mall Road in in Berlin, Washington County, Vermont. While in the store, the defendant had selected a couple of cans of alcohol and was approached by loss prevention. A defendant advised that he had put them back and had put one in his pocket, but intentionally passed all points of sales without paying for that item and was later seen drinking the item that they said he had stolen for a total loss of $5.94.
Mr. Martinez, to the retail theft discharge on October 30th of 2024, did you go into the Walmart in Berlin, Vermont, sir? While there, did you take some beer from the shelves and walk out without paying for it? Did you do so intentionally without paying for it? going to ask you for the charge of the misdemeanor charge of retail theft in this docket of, for March 30th, 2024. This is docket 13008, regarding the taking of beer from the Walmart. What is your plea to that, sir? Thank you. I'm going to hold off doing that until we can continue the other steps. This will have to do with the admission of the violation of probation, and I'm going to give me. So do you remember? I know around 2024, you would have been sentenced to a probation sentence in the Lamoille County case with the false information on law enforcement and violations of condition of release. Then at about the same time, had a probated sentence for burglary and the docket here in our county. That would have been 23 CR 77384. Do you remember going on to probation around that time, sir? And at that time of when you're on probation, was there a condition called A that read, you shall not be convicted of another crime or engage in criminal behavior? Remember that condition being imposed? Is that condition that was imposed at that time still in effect today, sir? I'm going to be asking in a minute about what we're going to do if you wish to admit to that violation. In a moment, I expect to accept the guilty plea to the false pretenses case, and that would serve as a conviction that could give me the factual basis to find a violation of that condition A across these dockets. And if you wish to have me do that, you'll be admitting that violation here in a moment. So, to the alleged violation of the condition not to be convicted of another crime across these two VOP dockets, with the conviction the guilty plea you're asking me to commit, to accept, serving as the factual basis for that, do you admit or deny the violation of probation, sir? Thank you. You may be seated, Mr. Martinez. I'm going to find that the guilty pleas you've entered in the admissions to the violation of probation are knowing, voluntary, with knowledge of the rights being given up. After adequate opportunity to speak to your attorney, I'm going to find they have what we call a sufficient factual basis. We're going to turn to the portion of the case when I'm asked to accept the matter. I see there is the restitution, and you realize also that anything else in that other restitution judgment order, by the way?
So we have the $5 one for Walmart that we just talked about,
$5.94.
and then
The other one I have in front of me is as the one for Sarah Dwyer. That's the 1,243 and 27. But there was a blank restitution judgment order for $5.04 for Kinney Drugs in the docket 24 CR 5871. My question is just, is that being pursued at this time? So we have to not being. So then what I'd like to do on the plea agreement going to be signed, where it shows those RJOs, it shows that case. I would like to be able to cross that out so there's no confusion that restitution is being sought in that. Is that agreeable to the state? I take it, Mr. Almonte, that's agreeable to you. Okay, that'll give us clarity. I don't know that, although there is, Ms. Dwyer, there is the restitution judgment order on her favor. Is there any victim statements or anything being?
statement, Your Honor.
Okay, very well. Would you like to be heard on the agreement?
Thank you. So the original victim in this case, Mr. Hart, has since died. So Sarah is his heir, so to speak, his daughter, which is why that's the name on the RJO.
I see.
The defendant has taken responsibility for these offenses, and sounds like he's doing okay. He has a job and is going to continue on probation and is working with probation. So the state feels that any issues of public safety are being addressed. He is also serving a punitive portion of 29 to 30 days that is going to be split over even a longer period because of his work schedule, and he's still willing to do that time to serve. So the state is going to ask the court to accept this agreement.
Mr. Armando, would you like to be heard on the agreement?
Thank you, Your Honor. We also ask the court to accept this for the reasons stated by the state. We think that it is an appropriate agreement Mr. Martinez will remain on probation, but has taken a responsibility for his slip ups last year and has the punitive component to it. So I think this is an appropriate agreement.
Thank you, Mr. Amanda. Mr. Martinez, you have the opportunity. There's no obligation. It's optional if you wish to say anything. Did you wish to say anything at this time?
Apologize for the victim, that's all, Your Honor.
Okay, well, thank you for that. Thank you. I'm going to accept your agreement. You've taken responsibility for these matters, and so are you able to put these behind you and know what just wrap these things up. You'll continue under probation supervision, which can be appropriate. There are concerns about future conduct. You have the restitution judgment orders for the two of the matters where people are seeking repayment for the economic loss. And so you'll have those. And there's the punitive aspect, sort of the reminder and deterrence, the to serve portion. Going to be a lot of trips to and from the correctional facility, but I'm glad it's something that can work where give you some time to think and give you some incentive to keep on a proper path going forward. But there's going to be a lot of trips up there, but I think you will be able to get it done and be successful. And it looks like it's structured in a way where you won't have the additional impact of having loss of job or disruption. That sometimes can become a significant collateral consequence if someone has a to-serve sentence. So I'm glad to see we have some flexibility there. You're gonna be busy though between if it's a six-day week, but you will get through this, sir. So what I'm going to do is I'm now going to be signing the plea agreement. There are two substantive pages to it. I'm going to be signing that. I'm going to be signing off on the restitution judgment orders here in a minute, and just the two of them. You'll be able to get copies of those. My staff will see that one of them is two-sided. The other one is two single pages, but we'll make sure they get entered. My staff is very good about getting them properly scanned in. So I've just signed the one for payable in favor of Sarah Dwyer. This is the one for the Walmart, which I'm about to sign. So we're going to be able to complete your hearing. Right now, I don't know if your probation officer wishes you to report today.
That's what I leave here.
Okay, very well. You'll be able to do that. I'm all set here. Anything further from the state? Anything further, Mr. Lamanda?
Thank you.
All right, good luck. Good luck, Mr. Martinez.
Good luck to you, sir.
Is Mr. Sawyer connected through?
Yes, Judge, thank you. I am.
Garno is connected through. He's in the number ending in 15. Mr. Garno, can you hear me okay? It's Judge Harris.
Yes, I can, Judge.
Thank you. And then let's see. Are you handling these today, Attorney Snow? All right, so Attorney Snow. I'm going to call the matter, State of Vermont versus Jonathan Garneau. I have Attorney Snow here calling the cases. They're most on. I have the dockets are 25 CR 1172, 25 CR 890. That one is Mr. Lamanda. These other ones will be Mr. Sawyer. Mr. And then there's 7681. Where we were is, as I recall, well, we're going to reset these. We were last together. The defendant had been participating in different treatment services. I think this was a treatment outside of a formal treatment court referral, I believe, but that was going to be taken into consideration as we went forward on these. But let me hear from counsel. Where do these matters stand at present?
Judge, first of all, I want to see if I can get Mr. Garneau's current phone number, because I have 3 phone numbers that, and the one I got from last time has now been disconnected. So I want to see what his phone number is, and I can't read it on my screen.
Okay, it's can I speak, Judge?
Yes, you can, sir.
Yes, it's 802-272-2615.
Thank you.
Thank you, Mr. Cardinal.
Welcome.
On the Mr. You take a report on Mr. Sawyer. You may have
Yeah,
lost contact with Mr. Cardinal, but where do these stand? But Attorney Snow, is that correct? These were treatment services being pursued outside of a formal treatment court, drug, the substance abuse court referral.
Right. So Attorney Waite said that the last our office knew is that he was at the Gatehouse in New Hampshire, continuing to pursue sobriety. We were looking to have that confirmed. If so, the state was going to offer, and Mike already sent the email, to please to the following prohibited person firearm, count 2, death of services, a VCR, and the sentence would be 30 days to 24 months, all suspended on probation for a 4-year term.
So you're looking at docket 25 CR 890 and the firearm related offense 25 CR 3791 theft of services with a probated sentence of what? I'm sorry.
Probated 30 days to 24 months, all suspended for 4 years of probation.
Okay.
VCR and count 3, 25 CR 1172.
VCR. Of course, the firearm, that actually there might have been a firearm charge in 890 and 1172. Were you looking at the firearm charge under the offer? Is that going to be in the 890 case or the 1172? I'm sorry.
Sorry, I missed.
Sure. I think the state charge of being in possession of a firearm, I think there is a count for that in the 1172 and the 890. And which
we're doing only, it looks like count 3 and 1172.
Okay, count only the 1172. Okay, got.
No,
Yeah,
so
I've got-
prohibited person fire, which is count 2 and 25 CR 890, and then only the VCR.
Got it.
In 1172.
Theft of services in 3791. Okay. Well, I don't.
Attorney Lamondo is also talking to.
Go ahead, Mr. Lamondo.
Just with Mr. Garno, I did have that number and had told him about the probationary officer, the 4-year term. He didn't like that. He wanted further discussions over the term of probation. But I think, you know, there's I think general agreement to on probationary officer. He does remain in New Hampshire in sober housing, doing well. Yes, that goes for the further questions that he wanted me to have with the state.
Is he still at the Gatehouse facility, or still has people transition from one thing to another?
I'm at the White Mountain Recovery Services.
Yes. Okay. Yep. When I was in Caledonia and Essex Junction, I had some came to have some familiarity with that program.
It's great. I love it up here. I don't want to come back to Barry.
Well, you see where you may have at some point you have options to go certain places, but right now I know that program is one where it's pretty robust with some of the program expectations. I think they get people out in the community with different services, looking at the job things and other more. It's more than just being there, staying there. So I do thank you for participating in that, Mr. Garno. I think it's helping make options available to you. We'll see if they're acceptable options, but thank you for that update.
Great. I've been doing great, Your Honor. I got a full-time job. I'm doing really good up here.
Yeah, I think it's a very good program, and yeah, there's the other aspects about their eligibility stuff, which I think it's a real it's a really great program. At least as I had it described to me, had some involvement with them. All right, so Mr. Sawyer, looks like you haven't had the opportunity to discuss things with Mr. Gardo, and you and Mr. Lamonda would need to have further discussions with them. The proposed resolution would span 3 dockets, including ones where each of you are representing Mr. Garno. Are we looking? Mr. Lamonda, what were you thinking about as the next court event to be asked for?
I was hopeful for a change of plea. I think given the probationary officer, if we can get some agreement on the term of probation, I think we'll have an agreement.
Okay, if we have a change of the, if Mr. Garno is in the Gatehouse sobriety program, I am open to having it done with him appearing remotely. So if there's a probated sentence, you're going to need to talk in advance what the probation folks going to need. So that's often the one where we need someone in here. And I think it looks like there'll be entering probation with some significant conditions. It's very likely may need to come here. So
I think that was actually, I think my messages with him did include that he would probably have to make at least one trip.
yes, okay,
That's
all right.
fine, Your
So
Honor.
okay, we could do that. If you could get, well, of course, kind of a saying in my head, ultimately either have a deal or don't have a deal, which means at one point you're going to need to see if you're able to get sufficient agreement where it is going to go forward. Um, what what you could do is if there is agreement, you can get council sign change of plea if it's difficult to get Mr. Garneau to sign off on it. We're not having him transport anything, but I'd like to see that there really is agreement, and we could have him sign when he's here. Attorney Snow, are you going to, for the at least now until at least February, be assigned to the case? Okay. All right. You can work with Attorney Snow on that. So why don't we, um, probably we should look to set this on Mr. Lamonda's block at a time when Mr. Sawyer is available to get you both able to attend. But the idea being a change of P slash status. Hopefully you'll have a change of play. Does that make sense?
Yes, it does.
All right. We're going to be able to work that way. Mr. Garneau, keep doing the good stuff you're doing there, okay?
I appreciate it. Thank you, guys. I'm willing to take responsibility. I just want to be able to live with something,
Well, you'll talk privately with your attorneys. It sounds like you're on a good track, and we don't have other matters coming in, and you're engaged in having that job up there, as fine. Your attorney can talk to you. So,
I've been clean for 100 days.
all right, thank you. So I'm going to complete the hearing. The one thing I'll note for council that you probably need to do is if that recovery program can have a long time durational time when people are there. If the defendant is looking to continue in that program, being in residence in New Hampshire after the change of plea, with the supervision aspect of probation, Vermont probation, you should discuss some of that with the probation office. If there's going to be ICOTS or some short time thing, there could be, if he's expecting to want to live there, there may be issues about coordinating that with his supervision on probation. Sometimes it may be certain amounts of period. So you have to see where things go. My recollection of the White River Mountain Recovery Program is the exit date, so to speak, and depends some on what's going on with the residents there and their success rate. So just something to think about as we come in. Okay.
Okay.
All right. Thank you. With that, we'll conclude your hearing, Mr. Garneau. Thank you.
Goodbye.
Thanks,
Bye
Judge.
now. Thank you. Thank you for your patience.
Autumn Welch before the next hearing because she's not here. Oh, is it?
It's Judge Harris here. It's Autumn Welch. Hello, Ms. Welch. I'm Judge Harris. Thank you for joining us.
I'm on the phone.
Yep, I figured as much. Are you on the phone? I'm Judge Harris. You can't see me, and it looks like you wouldn't be able to see the courtroom who's here. But you're able to hear me okay? Ma'am?
Yeah, my phone lags a little bit. So you'll hear me. You'll hear me, and it's just my phone sucks.
Okay, well, we'll expect a lag. Well, I'm Judge Harris. I'm in the courtroom. Your Attorney Lamond is here. I have a Deputy State's Attorney Snow. I'm going to call your case. We're going to talk about its status. It's State of Vermont versus Autumn Welch, docket 25 CR 1773 and 1023. So these are the two matters. I think the most recent one was arraigned actually out of Chittenden County back in April 11th. These cases came through, they're this here in Washington County. They came through the calendar call process on May 27th, but we're here for a status. Mr. Lamonda, where do these stand?
Yes, Your Honor, I actually just connected with Miss Welch. That's one of these for the first time knowing her to her. I think I have a message number was her mother and did speak to her from this number today that wasn't a great connection. I do know she remains in Chittenden County. I believe she's she will be one of the ones there. I think it's on my number after I reached out. The statements, maybe institution order. I think that was filed yesterday. So with Miss Welch being in Chittenden County, I just have to figure out how I can connect with her there. I'm sure we can resolve this case.
Attorney Snow, is there a global resolution offer extended?
I will do that
Okay.
before he talks there.
And so
Just have a simple assault and a retail.
that's correct. Simple assault against protected professional and retail theft, I believe. Mr. Lamonda, what would you like? What are you asking the court to do for our next hearing?
Yeah, another status / change of plea in 30 days. I going to Chittenden County more for court than I had. And I actually saw her there 3 weeks ago. We just happened to pass each other, and I wasn't thinking it. I haven't seen this far ahead that we had court coming up.
Okay.
I will get you an offer.
What we'll do if come back, if there isn't a resolution, we probably just set one of the matters pre-trial, probably the 1023 simple assault and protected professional. It's slightly older, but we'll take that up as need be. But I think if there isn't a resolution at the next hearing, we would just set one up for pre-trial. I mean, take it discovery. Discovery's all been received in these. Okay. And if there's a restitution being sought, it looks like there's a proposed order. I think that will work on our end. Does Ms. Welch have any Chittenden matters pending? President?
She does.
Okay, well, you can.
She was maybe in that pilot program, incentives for success.
Oh, yes, incentives for success. Yep. But you can double check with her if there's anything else that might result in the cross resolution. But all right, we'll leave it at that. Ms. Welch, you've been able to hear me okay?
Yes, sir.
All right, well, thank you. Thank you for attending today. Mr. Lamonda will be in contact with you to further, he's going to get an offer to resolve these matters. We'll have a hearing that will be setting it. I think later he'll have let him know what that is. And if it's just a status or something, she can appear remotely. If there is a global plea, it can be a remote appearance. I would consider it. There's difficulty getting here. Okay. All right. All set on that one, attorney. Okay, thank you, Ms. Welch. You can sign off. We've completed your hearing. I'm going to continue with my next hearing. Okay.
Yes.
All right. Thank you.
I actually have another county set up for hearing scheduled at 3.
Uh-huh.
So I was going to go like.
What's that?
Yeah, the last 3 that.
1 crack is fine.
What they like us to. What's the nature of the matter then? Sounds like it's a misdemeanor thing. I think we can accommodate a request to do a cite and release citation rather than conducting their hearing on the we just there was a Lamoille, someone from Lamoille brought in. They're asking Lamoille, I think, is asking us to cite the defendant for. Okay, so we will cite him for the. We can do a cite, or we can do a cite release, I guess, or a cite for the arraignment, and then we're going to be able to serve that up. We have the docket number on that, so I won't have to go on the record. Mr. Capron has completed an application for a public defender. We'd be able to put that into the Odyssey for the case later today. You can just let them know we'll be citing him. Let's see. Derek, are you going to be our citer? And we can put a copy of that citation into Odyssey. That's what we'll do.
I was telling the state, I have another court that I have other hearings at 3:30, so I've gotta grab my computer to log into another court.
Okay, very well.
I have 3 hearings here left, but they're all in person.
Okay, thank you.
Yes. I mean, we've made our offer, and it's a question of like, is he going? I don't think so. Let me see. Revoke probation.
Wow. Was it?
Okay. Yes.
That'll be in the morning.
It's clearly some working sample. I think continue.
Oh, Mr. Capron, hello, Mr. Capron. I'm Judge Harris. So the application for the public defender, I've approved it with the $50 copay. It'll go into the electronic computer matter, be up there. So you can just let them know when you go up there. And then you'll just have to appear. Okay.
Like he was.
Once you get your copy of that, you're all set, sir. Okay, you're free to leave.
When did that come in? Did that come in after he made that offer? Yeah, like his sex offer was to dismiss it. Because he was asking him to please.
Cool.
Mm. So it looks like he was He's not being transported. We're not going to do anything.
You're all set, sir. Thank you, Mr. Capron.
Looks like he was exact. Missing, but maybe. Everything is easy, Jeff. It's like it's just easy breezy, no problems. I can't imagine that that would happen, but
We're going to be waiting for Mr. Lamont to come back, but two of the matters, Mr. Wade, Harley Porter, is that going to be you, Attorney Donnelly, today? And then I know on the Wickwire, Miss, I know Attorney King, I have you on SL Wickwire, indeed. But they Harley Porter, Mr. Wade, have been assigned. Who's handling that for me today, or for the state, I should say?
doing Veal and Porter.
Okay, very well, thank you. Ms. Wickwire, my understanding is she still may be being held at Brattleboro Retreat. That's, I mean, we can take it up. We'll take it up with Mr. Lamont. I did see the psychiatric evaluation, but I think my understanding is she had been under the person need of treatment order, but I think she's still receiving services somewhere.
Yeah, I don't know where Attorney Lamont.
He just had he was co-scheduled for something at 3:30. He was trying to attend to that. We'll be able to go. These are all held individuals we don't expect to be present. So as soon as he gets back, we'll be able to get through them. And, I didn't realize until he just told me that he was had a scheduling conflict, but we'll get through these as efficiently as we can once he's back.
Bless you. Thank you. Yeah, so do that. Yeah, go do that. And in the inner, yeah, because I'm up to date on her, so. Pardon? I'm up to date on her.
I know
If
you
I
are.
need to cover her too, I will.
Do you want me to?
No, no. Okay, take it.
All right. I can come down as well. I wanted to get that done.
Ask, can I brighten your day any more than it's been brightened? It's like buttering up the pan. What the fuck? Fucking stuff. I have no problem doing this. Yeah, that's fine. As long as he wishes to, from his end. But yeah. The motion hearing? Wait from when? 9:15? I have a 12, 11, I have an 11:30 also with Mr. Seaton. That's so. If we got Mr. Seaton's bumped up until, to 9:15 and did it then, we could take that and free up to 11:15. I mean, that's fine. She may have witnesses coming, but the
can cover that one for her too. If she's, but we can do Mr. Veal and Ms. Porter first.
I have discussed the offer with him that he has not accepted at this point. I think large part based on the would be a plea to the L&L, the case that's on for pretrial. He does not want to plead to that, so that can remain on the trial schedule.
I mean, I think that it makes sense because so many of the VOPs are based on conditions A of the criminal conduct. And with us being on the December 1st pretrial conference and jury draw list, that it makes more sense to just try the L&L if he's convicted, that's the basis of the VOP. And at that point, the state would be looking to revoking the underlying sentence and having him serve something probably concurrent to one another, and then would likely withdraw the other VOPs. December but just looking at what else is on and think this would be very likely. And on one day. Yeah, so. Oh. I'm for the. I did that. One of the. That's one of the more. And in the that
Okay, well, we may, we'll expect a lag. Well, I'm Judge Harris. I'm in the courtroom.
I think that like the that have been yeah, I think applied here in an appropriate way.
023. So these are the two matters. I think the most recent one was arraigned out of Chittenden County back in April 11th. These cases came through this here in Washington County. They came through the calendar call process on the 27th. We're here for a status. Mr. Lamonda, where do these stand?
Yes, Your Honor, I actually just connected with Miss Welch. That's one of these for the first time going up to her. The message number was her mother and did speak to her from this number today. That wasn't a great connection. I do know she remains in Chittenden County. I believe she's the most she was in or was there. I think it's on my